So that's kind of where we are right now on equal parenting. There's a major disconnect between the public, the science, and the statutory laws.
Brian Ludmer is the owner of a law practice in Toronto focused on family law and parental alienation, as well as corporate law. He is an advisory board member to the Parental Alienation Awareness Organization and the International Support Network for Alienated Families, as well as co-founder of Lawyers for Shared Parenting. Brian was one of the drafters of Canada's proposed Equal Shared Parenting Amendment, Bill C-560. He also co-authored the book, The High Conflict Custody Battle. Brian, it's a pleasure to have you here on the podcast.
Pleasure to be attending.
Welcome. So this is a special episode of our podcast. Obviously, we're here in the midst of the Momentum Conference, which has been going this morning, and we've had a lot of interesting guest speakers so far. I'm really excited to chat with you today, given your legal background and also your advocacy background on issues such as equal shared parenting here in Canada. So I believe we have three topics that we want to get into during this time. We will get into equal shared parenting, from a family perspective and a legal perspective and policy, as well as therapeutic interventions in family matters, and then also parental alienation. So if that sounds good with you, then we'll move right into the first topic.
Sounds great. They're all great topics.
Okay, so just to set the stage, for equal shared parenting, in the last decade, we've had basically two major pushes, efforts at the federal level to change the law in Canada, which is the Divorce Act, is the main law, I believe, that governs child custody after divorce. And it was C-560 in 2014, where you were a principal drafter of that, and then C-78 in 2018, where you were a witness who spoke to the committee, I think, that was considering the bill, the hearings in Parliament. And unfortunately, we didn't have either of those pass a rebuttable presumption of equal shared parenting. But we did a lot of efforts, and the effort continues. So another thing I just want to say to set the stage is that both in the US and Canada, there's been a lot of public opinion research. So the polling on shared parenting shows that there's a lot of support across all demographic groups, men and women, wealthy and poor, various racial backgrounds, etc. Basically, there isn't a lot of public opposition to equal shared parenting. At the same time, there's also a huge body of scientific literature by researchers such as Linda Nielsen and others on the benefits to children of equal shared parenting time following separation. Children do better in school, they're better socialized, fewer conflicts and problems, better mental and physical health, etc. Yet at the same time, we face a dilemma, which is that this is an issue where people seem to want it, children benefit from it, and yet it is not reflected in the law. So what's your take on this dilemma that we face?
Well, firstly, I think you summarized it brilliantly. There are paradoxes all over the place here. Perhaps it's best to just share briefly my experience in Ottawa. It was quite an eye-opener to see the political process unfold in terms of its day-to-day workings. So as you said, I gave a presentation to the House of Commons committee that was studying Bill C-78. It was a completely different process from Bill C-560 in 2014. The latter was a private member's bill, conservative backbencher, and we eventually got about 80-something votes, which was not enough to get it into second reading, to get it into committee. And in large part, unfortunately, was because the Conservative government at the time instructed all the cabinet members, about 39 of them, to vote against. But for that, it would have been very, very close. Bill C-78, conversely, was a liberal government bill, not a backbencher bill, and it did not include anything on equal parenting. So there were a lot of presentations at committee in support of equal parenting. A lot of different groups presented and gave really detailed and thorough backgrounder papers, and generally met with a very good reception. There was some pushback in terms of domestic violence concerns because the bill was strengthening protections there. But the point that I had made was that we've had the maximum contact principle in our federal legislation for some 30 years, and it has lived harmoniously with the previously existing provisions dealing with domestic violence, and continues to live harmoniously with the enhanced domestic violence protections in the revised legislation. All a rebuttable presumption of equal parenting is an enhanced version of maximum contact. So there's really no conflict between the two. I was invited back to speak to the Senate committee studying the bill, and at that point, that particular parliament was winding up. There was obvious an election was being called, and basically the government told the Senate committee that if you make any changes to Bill C-78 at all, so that it has to go back to the House of Commons, we won't be able to push it through that particular parliament. So they weren't really open to changes. However, back at the House of Commons committee, we were successful in getting the conservative members of the House of Commons committee to bring a motion forward to add our equal parenting proposal, but it was outvoted because that committee was dominated by Liberal members. So that's the recent history of our attempts in Canada. If we look across the border, you have Kentucky, Arkansas, and we're on the verge of having Ohio, which is the 5th largest state by population, adopt rebuttable presumptions of equal parenting. And Arizona has something that, using different language in practice, is winding up with something very similar. So there definitely seems to be a trend there, and in part that's due to the great work of the National Parents Organization and other organizations. So I think the trend is clear. You indicated the social science literature. I'm on the scientific committee of the International Council for Shared Parenting. Last year was chaired by Ed Kruk of UBC, who's well known to many of you. Currently it's chaired by Jennifer Harmon, who's a professor at Colorado State University. And the scientific committee has amassed 300 or 400 international papers that support the concept of equal parenting. It's a fairly robust and overwhelming body of social science literature. So it's really at this point a matter of how do we sell it? How do we sell it to governments that are afraid of the issue? They're afraid of the issue because the more vocal elements of society don't want equal parenting. And yet, as you pointed out, 20 years of public opinion polling across all demographics show that the public as a whole strongly supports a rebuttable presumption of equal parenting. So in part, that's our fault for not being as organized as the various groups in the states have been, where they've had a definite organized platform of targeting each of the legislators over a one-year period and building consensus before they push to the final step of getting something introduced. So I think we need to do a better job here. We are in the process, myself specifically, of commissioning an update public opinion poll. And when that's done and we anticipate a similar result, we'll start a process of broadly disseminating that and making the point that the government isn't listening to the people. One other reason for equal parenting requires a bit of a rhetorical explanation. So I made the point in Ottawa that we have a very, very expensive family law litigation system funded by taxpayers. And the vast bulk of the cases are not extreme cases. They're not cases about domestic violence. They are cases where people are simply fighting over who is to be the primary parent in a parenting plan, but the background is that both are capable parents. That is the vast majority of the cases clogging our system today. Is it going to be a 50-50 split, a 60-40 split, a 70-30 split, or some variation thereof? Now, to spend the many, many billions of dollars that this system costs, clogging the system and delaying resolution for the families who have major issues that would benefit from judicial focus. And these are the parental alienation cases, the cases where there's substance abuse issues, the cases where there really is failure to parent in a normative fashion, and the domestic violence cases. If you take the bulk of the cases out of the system and state those can be resolved on the basis that equal parenting, absent some extraordinary fact, is going to benefit those families, we will have the judicial resources, the therapeutic resources, the parental coordination workers, and the therapists who can therefore devote their time to these troubling cases that really do need the attention. And I got a lot of nods when I explained that. But at the end of the day, politically, this was not going to happen. Another point that I made was that the current system provides no protection for children right on separation. Because today, right on separation, it's kind of the law of the jungle. There's no rules. Somebody can just grab control of the children and dictate the other parent's terms and not release the child unless a paper is signed saying that you're going to return the child by 6 p.m. And it's just not an appropriate way to assist families at the time of separation. And I got a lot of nodding heads in Ottawa when I explained that as well. Indeed, in Kentucky, they first tried a rebuttable presumption at the time of separation, but not for purposes of any final adjudication. And when that went well, and they saw that it was helping, they expanded it to the full gamut of family law decisions. So that's kind of where we are right now on equal parenting. There's a major disconnect between the public, the science, and the statutory laws. In practice, it's easier to make an argument for equal parenting today just jurisprudentially. But the problem is you get unequal results, different chance of success between provinces, between urban and rural centers, between having a judge in his 60s and a judge in her 30s. So this arbitrariness doesn't assist families. There's no predictability, and you do seem to get uneven results. So that's pretty well a description of today's landscape.
Thank you very much. And it's a complex landscape and fraught with problems, I think. One of the problems being this classic phrase, the best interests of the child. Like most judges are not properly trained in child psychology or developmental issues. They're trained in the law. And a lot of them are not aware of the research. And so they think that every single family needs its own custom solution and needs to be decided on a case by case basis, which is partially true, but they don't understand that the starting point for that negotiation or for that judicial process should be assuming that both parents are equally capable at taking care of the children, and also that the default 50-50 is, other things being equal, that is the best starting point.
Yeah. So I think some training in child development and the science would definitely benefit. Um, but judges just seem to think that they know that. And depending on their experience when they were in private practice, they may or may not be up to speed on the latest social science understanding. So I think to go the rest of the way, we are going to need a statutory change. And that will involve the various elements that I've already spoken to.
Okay, so just before we move on from this topic, I have two questions for you, which is, how can we improve our strategy for the next round of changes to the Divorce Act so that we can have more politicians across the spectrum on board with this proposed amendment? And also with the legal profession, so you're a lawyer, so you understand how lawyers think. How can we change their incentives so that they profit from family harmony instead of family conflict?
Okay, those are two very deep questions. Um, in terms of doing a better job, I think it's a matter of more resources so that a kind of script and briefing binder would be prepared, and then local groups within each federal electoral district would sit down and try and teach and lobby and explain their local MP. Because that is maybe one of the principal differences with the successful campaigns in the United States. They had really done their homework with all the elected legislators before they pushed the proposal through. And I think that's what we need, and it is going to call on a lot of resources and a lot of organization right across the country.
Right. So we do need that broad grassroots movement. And one thing that I've noticed spending my whole life in Canada is that this issue doesn't really get a lot of media attention or political coverage. It's usually way down the list after economic issues, environment, etc. So even just getting it on the radar for politicians, I think, is an important step.
Correct. And if we stress the public opinion polling, and we're going to expand our list of questions to ask people whether this issue would be influential in where they place their vote and publish those results, we may get some more traction, because you're 100% right. This is not a high profile issue, and it's our job to make it that.
Exactly. So let's go to the topic of therapy. So you had some views on therapy in a family context and the outcomes or consequences of that process and how it works differently for men and women. Do you want to share maybe your thoughts on this?
Sure. In a typical high conflict case, at some point along the way, the family will either self-refer to therapeutic services or it'll be part of a court-ordered referral. And in the particularly high conflict situations where children are aligning with one parent as opposed to the other, and there's all kinds of psychological reasons why that happens that I can't get into here, but it's very common. The typical therapeutic intervention is not only going to fail, but it will often make things worse. And that's obviously quite sad. It's not what anybody's intending. And there are structural reasons in terms of exactly what therapy is, what the premises are, and the foundational concepts of therapy that predict that these alliances will not be appropriately resolved in traditional therapy. And simply stated, the type of intervention that's needed in these circumstances. So we're not talking about a child who has problems with their peer group at school or is exhibiting anxiety generally or is disruptive in class. We're talking about a child expressing relational issues with one or perhaps both parents. You cannot solve relational issues in a siloed individual therapy session with a therapist and a child. And it's amazing how many therapists don't realize that. In addition, you have parents shopping the child around until they find a therapist who is prepared to meet with only one parent and child and do therapy involving relational problems and write a report for that instructing parent to use in court. And there's so much wrong with that in terms of breaches of professional standards, both substantive standards and ethical standards. And yet it's remarkably common. So you may have, for example, some sort of other court intervention like a parental coordination process happening, which has as its goal supporting compliance with a court-ordered parenting plan. And then in parallel, the child is seeing an individual therapist whose work is undercutting the other process. And that is also remarkably common. So what is actually required is not therapy, but a outcome-defined, directive psychoeducational process where the patient is actually the entire family system as opposed to any one member. And we say effectively to that practitioner, here's a broken family, work with them all to achieve the objective set out in the court order, and you can be forceful. You can push people out of their comfort zones. You can demand changes in behavior. Ultimately, you can write a report for the court if people are not complying in good faith and surrendering past narratives. So it's an entirely different process from therapy, even though it may be called reunification therapy or reconciliation therapy or family therapy. All of its elements differ from what is traditionally understood to be a therapeutic relationship. So in a nutshell, those are the pitfalls that will be present in a typical high conflict family situation where the family system just doesn't settle down into a healthy pattern post-separation.
Right. Well, I definitely know one thing you mentioned, which is suggesting changes in behavior in a typical psychotherapeutic process. That is not something that therapists do. It's against their MO for treating patients. So if you have an activist, well, maybe not activist, but uh, a therapist that's more comfortable with intervening in a family and suggesting, hey, you should do this in order to improve your family dynamic, that's definitely a different approach. It's a different model.
Correct.
Hmm. Um, do you think that therapy, as it's currently structured, are there any biases against fathers or men who are trying to heal the family dynamic, or perhaps keep good relationships with their children? Have you seen any differences in how it treats mothers and fathers, or men and women?
Um, the gender-based concerns may be based on the same kind of residual concern that there's an inherent bias that mothers are nurturing and fathers don't come with the same natural skill set. But beyond that, I think it's more the therapist getting embroiled and being used by one parent even unknowingly, because whoever can control what the children are saying to the therapist is eventually going to get the therapist on that side, because the therapist is generally not going to challenge what the children say, because if they do, they know the children are just not going to come back. And they wind up inadvertently personalizing the whole thing. Many members of the helping professions, they're there for a reason. They like to help people and they feel they can help people. And once they establish relationships with the children, they don't want to let them go. And they stay with a case far longer than they should. Most professional standards, so be it social workers, psychotherapists, psychologists, their professional standards require them to resign if the work they're doing is not going to be effective within a reasonable period of time. It's kind of an extension of the first do no harm principle. And that is also generally observed in the breach. So it's less so a gendered concern than it is they don't think forensically in terms of what they're being told by the children. And so who controls the children's voice in those circumstances? Quite often the parent who has had the primary responsibility for the child care, or who got out early in trying to co-opt the children onto their side. So if statistically there's a difference between the genders there, that will ultimately reflect itself in the therapeutic process. So the ultimate high conflict situation is where one parent is entirely losing their relationship with the children. And the term parental alienation goes back hundreds of years. You'll find US and UK case law from the early 1800s that use the term. So Dr. Gardner, who was a child psychiatrist and in the 80s proposed a construct that he called parental alienation syndrome, really didn't invent the term. For example, it's fairly well known that Albert Einstein complained bitterly that he was being wrongfully alienated from his children. And that's just one example. These cases are intractable, very, very difficult to solve. They require an intense focus and an understanding of psychology, family therapy, family systems, the law, the structured programs that seem to work, and they need to be tackled from the earliest moment that these alignments start to show themselves, or else they're really difficult to solve. Thankfully, in Canada, we have the most robust series of jurisprudence on alienation of any country. We should be able to get a favorable result in a Canadian case. That's kind of where we're at today.
Okay, great. Thank you very much. It's a very difficult problem to solve, and we'll continue to work away on it with our network of experts here in CAFE and CCMF. I think David would like us to go to questions now, so we will do that.
So one of the questions is, isn't the objection to presumed shared parenting a fear on the part of women losing child support? In other words, isn't it an economic objection in some cases?
It's hard to generalize motivation. I think you can just as easily say that there's a fear of losing control. There's a fear of losing status as a primary parent. There's a fear of losing status amongst their peers. It's very different in Quebec, where it's considered progressive to be a mom and share parenting. It's very different in Sweden, where it's considered progressive to share parenting. So that's what I can say. It's just hard to generalize about motivations.
Okay. And the next question is a bit of a long one, but it says, hi, Brian. As a lawyer, are you aware of the MIP required for parents starting the separation and custody process? However, there are certain lawyers advising women not to attend the process, as it could lead to mutual resolution before going to court, and it is against the financial best interest of the involved lawyers knowing and using legal aid to their own gain, but not at all in the best interest of the children or conflict resolution. How do we address this problem? That being unscrupulous lawyers gaming the system for their own gain, as well as women to manipulate or control men to make them settle, either because they can't afford to go ahead with the legal aid funding from the mother, or because the father simply wants to be reunited with his children and willing to settle and give custody to the mother in trade for closure of the court's involvement in seeing and being part of the child's life again. It is immensely one-sided and detrimental to both the father and child's mental health. How to deal with this systemic issue?
Okay, well, there's about 3 or 4 statements bundled in there with about 2 or 3 questions. It started off with a reference to the MIP process, and that's really quite minor. It's mandatory. You can't avoid it. It's really just part of educating participants in the system about how the system works, and that they have options such as mediation, parental coordination, etc., as opposed to pursuing the legal system. And you can't advance a case without both clients doing their MIP. So I think the question is a little bit misplaced. As to the balance of that, there's just so much there. I wouldn't even know where to start.
I guess the main thrust of it is there a way to prevent people from trying to, unscrupulous lawyers from trying to influence it not to go towards a resolution and to draw it into a custody or a court case so that they can get more legal aid? Or is that something that you've seen?
I would view it this way. I believe people should be informed consumers of medical services, of home renovation services, and of legal services. So you're the client. You have to understand your goals, your objectives, and think critically of advice you're given. And ultimately, you set the strategy on advice. And if it doesn't make sense, or it's a time for settlement proposal, and you're not getting a warm and fuzzy feeling from your counsel, it's time to switch counsel.
Okay. Thank you, Brian. And Warren, I'll hand it back to you to do your closing question or to wrap up. Thank you.
Sure. There was I just want to ask one final question about women, I guess mothers and child support. One of the arguments against equal shared parenting is that when you divide the time equally, there will be a reduction in the amount of child support or alimony, perhaps that one parent, typically the father, pays to the mother. Um, but how would you answer this? I've heard from others that I've heard an argument actually from some women that the advantage of spending less time being a parent with your child, physical custody, is that you have more time to work and you have more time to earn income and advance your career. So there is actually potentially a female professional argument for shared parenting, but with less financial transfer from the father. Do you have any views on this topic?
I always like to separate the issues of what solutions do we need to protect children from conflict. Fighting over the parenting schedule is the number one source of conflict. So we need to solve that as quick as possible in cases and hopefully avoid conflict there at all. Now, the implications, once you decide what's in the best interest of the children, are self-regulating. So in the typical scenario where one parent significantly out-earns the other parent, even if you had equal parenting and subject to some complexities, you visualize support at that point as each parent pays each other support based on their income. Well, the lesser earning parent is not really contributing that much in relation. So you're not really fighting over that much money. You're going to spend way more money, and the system is going to spend way more money fighting over the parenting. In cases where there would be a meaningful offset, maybe both parents earn roughly the same amount of money, then yes, there's a financial incentive for a parent, could be the father, could be the mother, to try and keep the other parent below 40%. The question is it worth it, and how much are they going to spend to try and achieve that? At the end of the day, from a public policy perspective, an intact family typically operates on a blended pool. So if you have two middle-class type parents, all that money goes into a pot and helps pay for everything. So from a public policy perspective, there's nothing wrong in that continuing post-separation. And that's my take on it. I really like to separate the two issues: children's needs to avoid conflict and have stability quickly after a separation, and the support issues will take care of themselves.
Okay. Thank you very much, Brian, for your answer. I think our time is up now for this session, so we will close and hand it back to David to continue the Momentum Conference. But I just want to say it's been a real pleasure to speak with you. We will put this, of course, on YouTube, and I hope we get a chance to talk again in the future.
My pleasure. Thanks for having me.
Thank you.